History as it happens, September 14th, 2021. The Supremes.
Today I am nominating Chief Judge Merrick Brian Garland to join the Supreme Court.
American people may well elect a president who decides to nominate Judge Garland for Senate consideration. The next president may also nominate somebody very different.
Judge Neil Gorsuch of the United States.
Thank the members of the United States Senate. Senate Majority Leader Mitch McConnell for his leadership and steady resolve.
Supreme Court Associate Justice Ruth Bader Ginsburg has died at the age of 87. Just weeks before
Thank you, President Trump, for selecting me to serve as an Associate Justice of the United States Supreme Court.
Supreme Court decisions are once again sending some Americans into an uproar, provoking criticism that the justices are too partisan, too ideological, at a time when Americans are separated by partisan and ideological chasms of their own. This is nothing new, even if it seems worse now than ever before. That's next, as we report history as it happens, a podcast from the Washington Times. I'm Martin DeCaro.
The Supreme Court has always been ideological, but since 2010 is the first time that ideological lines in the court have coincided with partisan lines.
Over the weekend, while we were watching football, or while I was watching football, Supreme Court Justice Amy Coney Barrett made some remarks at a center named after the man who made sure her nomination sailed through the Senate right before the 2020 election. That was the McConnell Center at the University of Louisville. She told her audience, "My goal today is to convince you that this court is not comprised of a bunch of partisan hacks." The new justice is apparently concerned Americans view the court's decisions as political, not impartial. She said judicial philosophies are not the same as political parties. Well, it's obvious why Justice Barrett felt she had to reassure us. Recent unsigned opinions dealing with major issues such as abortion came outside the court's normal process. Instead, they came from the so-called shadow docket. And Barrett herself personifies, through no fault of her own, the bitter politicization of the nominating process. As we all know, Senate Republicans refused to give Merrick Garland so much as a hearing in 2016, based on the idea that in an election year, the next president should make that pick.
It seems clear that President Obama made this nomination not with the intent of seeing the nominee confirmed, but in order to politicize it for purposes of the election.
But then after Ruth Bader Ginsburg died in September 2020, Senator Mitch McConnell forgot what he said 4 years earlier and made sure Amy Coney Barrett would be confirmed just days before voters went to the polls.
This is one of the most brilliant, admired, and well-qualified nominees in our lifetime.
Battles over the court date to the dawn of the Republic. I bet you haven't read the Judiciary Act of 1801. Well, that's okay because I haven't either. It was passed in the last days of the John Adams administration after the incumbent had lost the election to Thomas Jefferson. It allowed Adams to appoint the so-called midnight judges, packing new vacancies on the bench with Federalist judges. Jefferson and his Republicans were outraged, of course. But as it turned out, Jefferson had no real quarrel with most of Adams' appointees. The point is, there's never been a golden age when the Supreme Court was hermetically sealed off from politics. Nor has there ever been a time when the justices held no discernible ideologies. Judges have judicial philosophies. They have worldviews. They have their own interpretations of the Constitution. We tend to criticize them as ideologues when they issue opinions that we don't like. But this history does not negate or minimize our current problems, of course. We are living in hyper-polarized, hyper-partisan times, and the Supreme Court seems to be part of that, or maybe a result of that. So let's have a conversation now with Lawrence Baum, Professor Emeritus of Political Science at Ohio State University, and the author of Ideology in the Supreme Court, published in 2017, among many books on this subject. And his textbook on the High Court is now in its 14th edition. Lawrence Baum, welcome.
Thank you very much. It's very good to be with you and get a chance to talk about some interesting things.
We have a lot on the docket, so to speak, today. But first, I want to ask you a little bit about how long you've been studying the Supreme Court. This was your area of expertise for decades, right? And to what extent has your focus changed as the court has changed?
Well, I guess I've been watching the court a little more than a half century now. So a lot of things have happened. And I don't think my focus has fundamentally changed, except that we are in unusual political times. I think those of us who follow the court are interested in things like partisanship and its role in a way that we weren't in the past.
Politics has always impinged on the court, right? But it's gotten worse in your view?
Well, I think a couple of things have happened. One is that people in politics care about the Supreme Court a great deal today. And that's sometimes true historically, sometimes hasn't been true. But the level of interest in the Supreme Court, what it does and how much people care about it, is at a pretty high level now. The other part is that there is, of course, great partisan polarization. There's a more winner-take-all kind of mentality, a feeling that somebody wins, somebody loses. That was always there, but is stronger now than it's typically been in the past. And there's one other element that flows from that. The Supreme Court has always been ideological, and I think we'll talk about that some. But since 2010 is the first time that ideological lines in the court have coincided with partisan lines. In other words, all the Democratic appointees on the court are liberals, all the Republican appointees are conservatives. And strange as it might sound, that was never true in the past. And so the court looks different from the outside from the way it looked in its history prior to that time.
Yes, there are famous or infamous, depending on which side of the aisle you sit on, examples of presidents appointing a justice thinking they were going to rule one way. I think this happened with Nixon, right? And they wind up ruling another way.
Well, that's right. Presidents are much more careful now. They give much more emphasis to ideology above everything else. And that's why we have this unprecedented situation in which partisan and ideological lines coincide.
Well, I do want to get into all of these issues, but as is often the case, some issue pops up in the news and adds another question or two to my list. President Biden announced his vaccine mandate plan, and it has been pointed out, an essay in Politico, that in 1905, a Supreme Court case, Jacobson versus Massachusetts, that 1905 case upheld the authority of state governments to enforce laws that require their citizens to be immunized and, more generally, ruled the state can introduce reasonable regulations to protect the public health. Do you believe this case will come up if the Biden plan goes before the court?
It's a very good question. The Jacobson decision gave state and local governments very broad powers to require vaccinations. And it's interesting reading that opinion of the court, how closely it tracks the current situation. And so if the court were to rigidly adhere to precedent, the Jacobson decision would give state and local governments pretty broad power over vaccinations for COVID. Now, state powers are not the same as federal powers. And so if President Biden's orders were to be challenged, Jacobson might not be a direct precedent. It might not govern the court's decision. And of course, the court is not bound to adhere to its past decisions either. That's a long time ago. So the application of that decision to President Biden's orders is fairly uncertain.
So the shadow docket, this came up because of the Texas abortion law. The Supreme Court decided to, I'll let you explain it. What did the Supreme Court actually do when it came to the Texas abortion law? It didn't issue a final ruling, but it did issue something through what's known as a shadow docket. What are we talking about here?
Well, this is a technical matter that those of us who follow the Supreme Court never used to pay much attention to. But we do now because it's become more important. Individual justices and the Supreme Court as a whole have power to issue stays or injunctions that block lower court decisions from going into practice, and that sometimes block programs of the other branches of government from going into practice. So the lower courts in this case involving the Texas abortion law Well, the district court, the trial court for the federal courts, was going to have a hearing to determine whether the law should be blocked to keep it from going into effect. The Court of Appeals said, no, you can't have that hearing without issuing any explanation of their decision. So the case came up to the Supreme Court at the last minute, and the court decided it a day after the last minute as to whether the Texas law should be blocked. And the court decided by a 5-4 vote, the law should not be blocked. It should be allowed to go into effect. Though the brief statement for the court said that we are not ruling on the constitutionality of the Texas law. We're just saying that it's premature to reach a judgment about it because of procedural elements of the law.
People on the left are rather annoyed that the Supreme Court didn't block the law immediately. Are there concerns that this shadow docket is straying from the normal process? I mean, are those legitimate in your view?
Well, the big cases on the shadow docket are a small proportion of all the applications that people come to the court with for stays or injunctions. But what has happened in recent years, to some degree, this happened beginning in 2017, but it's accelerated in the last year or two, is that the Supreme Court, in deciding whether to block a lower court decision or whether to block a government program, is now in effect making decisions with great impact. Immigration. Can the government go ahead and do what it wanted to do, or are we going to stop that pending later action? And the important thing about this, or at least the most important thing, is that often when the court decides whether or not to act in a preliminary way, that's really the last word. That's really the last time it deals with the issue, because if it allows a government program to go into effect, then it may be too late to stop it later. If it doesn't allow it to go into effect, it may never go into effect. And so the court, without having full briefing, without having oral arguments, usually without issuing a real opinion, is settling major matters of public policy.
Without a lot of transparency, right?
No, there's not a lot of transparency. Sometimes the court will issue a brief opinion, as it did in this case. Sometimes it will issue a longer opinion. More often than not, it will issue no opinion at all. Now, there will be opinions for individual justices, but not a fully laid out rationale for what the court as a whole has done. And whatever side you're on, many people are troubled by that.
We began by touching upon the sharpened ideological or partisan lines, not just on the court, but in society. Do you agree with the notion that each side in our culture, if we can say there's only two sides, right, versus left? I think there are multiple sides in any society, but for the sake of discussion, that each side seeks the court or the court's favorable ruling because there is this sense that legislating change has become too difficult.
Well, I think that's a very important point you make. Obviously, Supreme Court decisions, court decisions in general, are always important. But with Congress not acting very often on major issues, that leaves even more room for the courts to settle those issues. And so you're quite right to emphasize that. And of course, people outside the court care more about the court's decisions now, particularly for partisan reasons, than they have at some other times in our history.
So as to when these concerns started to become more prevalent, the great historian Sean Wilentz, who's been on our podcast several times, in his book, The Age of Reagan, says, under Reagan, a new centralized screening process drastically diminished the influence normally exerted by the American Bar Association in rating nominees, and not just nominees to the Supreme Court. We're talking about the entire federal judiciary. Wilentz goes on to say, instead, officials and staff members at the Office of Legal Policy at the Justice Department scrutinized the records of possible judges and conducted day-long personal interviews asking candidates directly about their opinions on abortion, affirmative action, and criminal procedure. Wilentz says this kind of arrangement was unprecedented. But what it did do, Lawrence, was ensure that reliably right-wing or conservative justices would be, or judges would be nominated.
Well, it may be that Professor Wilentz, in the last part of the passage that you quoted, exaggerated a bit. But what happened is that Republicans and conservatives had become increasingly frustrated by what they saw as the excessive liberalism of the federal courts and the fact that the courts remained too liberal from their perspective, even after Republicans had had the chance to appoint an awful lot of judges, including Supreme Court justices, beginning with the Nixon administration in 1969. So by the time the Reagan administration came along, there was a feeling on the part of conservatives that we just have to make a more concerted effort to ensure that when a Republican president appoints federal judges, that they are truly strong conservatives, so that we'll have fewer of these disappointments that we've had with some Republican appointees to the Supreme Court in particular. And so Professor Lawrence is certainly right that that was a turning point in that presidents have always paid attention to ideology. But now there was an effort to do so more carefully and more systematically.
To make sure I'm getting Sean Wilentze's words correctly, here's what he says. Interviews of any sort were unprecedented, and previous officials at the Justice Department, including President Eisenhower's Attorney General Herbert Brownell, denounced what they deemed a shocking ideological politicization of the process. But you're saying that's not necessarily the case.
Well, it's hard to untangle things. They say presidents and the people working with them always cared about ideology, but often it wasn't the primary consideration. It certainly was not for President Truman or President Eisenhower or President Kennedy. And it was really only a limited consideration for President Nixon. So politicization can mean many things. Politics was always taken into account, but ideology as a specific aspect of politics, yes, it was now being given more attention than had been given in many eras in American history, including the recent past. The Reagan administration certainly was something of a turning point, though it's worth emphasizing that Jimmy Carter, who never had an appointment to the Supreme Court, just had bad luck in that respect, his administration had ratcheted up the role of ideology in selection of judges as well. So it wasn't as though there was a sharp break, but certainly there was a new level now.
Prior to our discussion, I shared with you a video of a recent Senate hearing titled, "What's Wrong with the Supreme Court?" It was chaired by Senator Sheldon Whitehouse, Rhode Island Democrat, and in his opening statement, he rips into the Federalist Society and its anonymous big money donors for, as he put it, taking over the nominating process, not just for the Supreme Court, but for the federal bench.
A private organization has long sought influence over judicial nominations to be the good housekeeping seal of approval for conservative judges. But when President Trump formalized this gatekeeper role, things turned toxic.
And as I listened to him, I was wondering, is there such a process on the left?
Well, there is something called the American Constitution Society, which grew up as a liberal alternative to the Federalist Society because liberals saw how much success the Federalist Society had had in a variety of arenas. It's not nearly as powerful. It's not nearly as influential, though perhaps that will change in the future. If we go back to the complaint that Senator Whitehouse and others have made, certainly in the Trump administration, the Federalist Society became very important. Remember, President Trump said when he was a candidate for president that he was going to pick really great justices, all chosen by the Federalist Society. Well, that's a pretty big thing. But that gets to the point. The Federalist Society was very important in the Trump administration because the Trump administration saw an advantage to making them important. It's not as though somehow they took over. The president and people in the president's administration saw it as advantageous to make use of the Federalist Society as a way of getting the kind of judges that both the society and the people administration actually wanted.
Whether it's on the left or right, should American citizens be concerned about this type of interference, if you want to use that word, from interest groups?
I guess that I don't see that as a major problem as long as it is relatively visible. And of course, one of the things that Senator Whitehouse has complained about is that a lot of what happens there is not visible. But leaving that aside, it's inevitable that presidents are going to listen to interest groups that are associated with their party. And the Federalist Society is dominant in the way that no other group is. And maybe that would be a cause for concern. But it's hardly illegitimate, and it's certainly not new that presidents have taken allied interest groups into account when they select judges. Now, there's more of that happens than there was in the past, but it's not a new phenomenon, And as long as it's reasonably transparent, I don't think that there's anything improper about it.
Is it true that there are more 5-4 decisions today than there used to be, and that's an indication that the court is divided upon ideological lines?
Actually not. The percentage of unanimous decisions has been pretty stable over the last several decades. Percentage of 5-4 decisions has been pretty stable over the past several decades. And actually, the proportion of 5-4 decisions is probably going to go down over the next few terms because the court's ideological split is no longer 5-4. Go back to something I said earlier, is not the extent to which the court is divided ideologically. That's been pretty stable for quite a while. It's the fact that there is this partisan cast of that division that makes the court look more ideological, but that's really an illusion. The ideology is more visible because it coincides with party, but it was there already.
Thank you for that. 6-3 is the more relevant ratio, I suppose, now. So let's take on this notion that the Supreme Court, the 9 people in the robes, are not supposed to be partisan or political, by examining some of our history. So let's talk a little bit about the Midnight Judges of John Adams. Why does that episode matter for our discussion today? Or is it irrelevant? Am I just plucking some historical comparison out of left field?
Well, here you have John Adams having been defeated for re-election in 1800. But there was an even longer period between the election and the inauguration of a new president than there is now, and gave him time to select a bunch of judges. And that was regarded as very controversial. But what that tells us more than anything else is that presidents and the people who work with them cared a whole lot about who sat on the federal courts then, just they do now. And so I think it's more symbolic of the continuing importance of the Supreme Court to people in the other branches than anything else.
And Jefferson seemed to loathe John Marshall, who was the Chief Justice at the time, right?
Well, as you say, the politics was there because the courts were seen as important. And given that John Marshall, the Federalist appointed, Adams appointed Chief Justice, had a great deal of sway over his colleagues during the more than 30 years that he served, and given that the court was establishing some key principles of law that were consistent with the Federalist point of view, it's easy to understand why the Democrats or Democrat Republicans, depending on what period you're speaking of, were unhappy about Marshall, unhappy about what Adams had fermented.
So let's touch a third rail together. Expanding the court. Today, some liberal Democrats believe it's necessary because, frankly, they don't like the current makeup of the court. I doubt they'd be talking about expanding the Supreme Court if it was 7-2 in their favor, right? But the number of justices on the Supreme Court used to fluctuate before the number 9 was settled upon after the Civil War. Can you explain some of the history there?
Well, let's start with just one piece of constitutional law. The Constitution doesn't indicate how many justices should be. So Congress and the president, through simple legislation, can change that number anytime they want. And as you said, during the period up through the 1860s, the number was changed several times, sometimes for political and partisan reasons. After 1869, there were no other changes. And so the number 9 became fixed in people's minds as the appropriate number. And then when President Franklin Roosevelt proposed legislation that would have given him the power to select 6 additional justices, I think a great many people, even those on the Democratic side, view that as illegitimate. First of all, it's a very large change, much larger than any change had been before, but it just seemed illegitimate because that number 9 had become fixed in people's minds. Again, the Constitution doesn't require it, but I suppose we could say it had acquired a kind of quasi-constitutional status. And of course, those on the Democratic side today who want to add justice to the court, they face that same perception that it's fixed at 9 and to change it would be illegitimate. And so even though there's a great deal of talk about it, and there'll be more talk about it if the court makes major conservative decisions in this term, it's not going to change. There's just not sufficient support. President Roosevelt had big majorities of Democrats in Congress. He couldn't get it through. President Biden doesn't have big Democratic majorities. He doesn't even support it himself. And so it's not going to go through.
I was going to ask you whether you believe this has any chance. I'm not even sure it's a good idea. FDR, for such a brilliant politician, the way he handled the so-called court packing scheme was pretty ham-handed, wasn't it? Didn't he have this idea that older justices would have to retire when they reach a certain age based on whether their vision, they had problems with their vision?
Well, no, actually it was, you're right about the older justices, but it was a little different from that. Roosevelt's claim was that older justices just couldn't keep up with their work, so they needed help. And so the legislation he proposed actually said the president can appoint one additional justice for every sitting justice who is over 70. And it happened at that time that 6 of the justices were over 70. And the term ham-handed you use is a very good one, because everybody knew that wasn't Roosevelt's motivation. They knew he just had a hostile Supreme Court, and he wanted to add justices to ensure it wouldn't be hostile to his programs. And that was a ham-handed part. He wasn't even being honest in the first place. Now, I think if he had been honest, it still wouldn't have been enacted. But that became a point on which people could criticize him. And in fact, the Chief Justice made a point of announcing that we're keeping up with our work. We're not having any problems. We don't need any additional people. And that really undercut Roosevelt.
Yeah, he was concerned about losing his legislative program, but as it turned out, the court packing scheme went nowhere, but the court, as constituted, did save the most important aspects of his New Deal program. I think today, Democrats are saying, look, we've been bringing a knife to a gunfight, pardon the expression. Mitch McConnell's been whipping our butts when it comes to appointments to the court, the treatment of Merrick Garland, then Amy Coney Barrett. And they believe this is maybe the only way to counter that, because it's not like Supreme Court openings come up all that often.
Well, that's right. I spoke earlier of the frustration that had developed among conservatives that culminated in the appointment efforts by the Reagan administration. Now we see the same thing on the other side. The Democrats facing a Supreme Court that's going to have a conservative majority for a long time. Actually, there was something of a conservative majority beginning in the early 1970s, but this is a much stronger one because all the Republicans on the court, all the conservatives on the court are strong conservatives. And so I think the Democrats are just grasping at straws because they see a kind of grim future from the court. And even though I think all of them recognize that adding members of the court is almost surely a losing proposition, it's about all they've got.
I'm not sure this excessive politicization or ideological current is going to turn around anytime soon. I think there's just a lot of leftover bitterness about Merrick Garland, who was a centrist. He was no left-winger. But the treatment of Garland and then Amy Coney Barrett, of course, the Brett Kavanaugh situation left a lot of bitter feelings as well. There's talk now that the current Chief Justice, Roberts, has lost control of the court because there are 5 more conservative justices to his right on the bench, and therefore it is out of balance, as the critics might say. What are your thoughts on that?
Well, first of all, the idea of losing control is an interesting one. To the extent that the court divides ideologically, and of course it doesn't in most cases, but to the extent that it divides ideologically, the justice who's in the ideological center is not necessarily the most powerful, but has the most impact. For a long time, that was Justice Anthony Kennedy. Then it became Chief Justice Roberts. And now, as you say, it appears that because the other 5 Republican appointees are to Roberts' right, he no longer is in that central pivotal position that he was. And of course, his dissent in the abortion case is one example of that. So it's not as though it's control in any direct sense, but it's who makes the most difference, is most likely to determine which way a case goes. And again, for that subset of cases in which the justices respond ideologically, it's true that Roberts is not in the same central position that he was for a few years.
Ruth Bader Ginsburg, liberal icon, criticized, however, for not retiring when Barack Obama was president. And Breyer is receiving some of that same criticism now, that he should step down while there's a Democrat in charge. What do you make of that?
First of all, there is a tendency for justices, in fact, to retire when a president of their party is in office. And so if Ginsburg had done that, if Breyer did it, it would hardly be unprecedented. Would Justice Kennedy have retired if Mr. Trump had lost rather than won? Maybe not. So it's not as though this would be an unprecedented kind of thing. But the fact that Ginsburg chose not to retire, the fact that, at least up to this point, Breyer chose not to retire, the fact that they received so much criticism is really a product of Democratic frustration more than anything else.
Yeah, I mean, it bothers me. I don't want to see the court the focus of such intense politics, but as we've been discussing, that's not necessarily new. Justice Breyer actually gave an interview to NPR where he called the abortion case or the abortion ruling very, very, very wrong. And then he said, I'll add one more very. A rare interview. Justices don't often do public interviews.
And when they do, when justices do give public interviews, they're often fairly circumspect in talking about decisions the court has reached and their feelings about them. And certainly Justice Breyer has generally been very circumspect. And so what he said in this particular interview is pretty striking.
And you said something interesting before. For all the talk of partisanship and ideology, there are still many 9-0 decisions. But I do think there is something to the notion that the U.S. Supreme Court has taken on a role of really paramount importance, that the most important or most of the critical issues of our time are at some point going to wind up before the court, which has the final say.
Well, I think there are always exceptions to that, but you're absolutely right in saying that a high proportion of big issues end up in the Supreme Court. What we have to keep in mind, though, is that that's not new. It's been true at least for several decades. And even in earlier periods, big issues like the role of the government in the economy often ended up in the Supreme Court. That was what President Roosevelt's court packing plan was about, that his plans to reshape government's role in the economy were being knocked down one by one by the Supreme Court. Now, I think since the 1960s, it's fair to say the court has played a more central role in dealing with a broad range of major issues than typically had been true in the past. But it's certainly not new in our current period now.
Why the 1960s? Was that a turning point?
I think it was because this was the last time in which the court had a liberal majority. And there was a period in the 1960s when the liberals were strong liberals, and across whole fields of civil liberties, they remade the law to expand freedom of expression, the rights of criminal defendants, racial equality. And that marked a point then where the Supreme Court was addressing a broad range of major issues. Not that that hadn't happened before, but ever since then, what you mentioned a few moments ago about the court dealing with a high proportion of the big issues in society, that's really been true since the 1960s with what the court under Chief Justice Earl Warren did in the 60s and what has happened under his successors since then.
And I certainly don't mean to imply that's a bad thing. I mean, after all, that is what the court is for. But there is a feeling, at least on the part of some on the left, that two of the justices are either illegitimate or don't belong there, Brett Kavanaugh and Amy Coney Barrett.
Well, I think that's right. Again, the perception that one or two appointments to the court were illegitimate during the Trump administration, people can argue whether that perception is appropriate or not, but it just adds to what would be great frustration on the part of liberal Democrats under any circumstances, because it's clear the court is going to be making conservative decisions on most big issues for some time into the future. And so a frustration at that prospect is inevitable.
Lawrence Baum, this has been great. We thank you for sharing a half-century's worth of expertise on this matter. On the next episode of History as It Happens, vaccine mandates are here.
Despite the fact that for almost 5 months, free vaccines have been available in 80,000 different locations, we still have nearly 80 million Americans who have failed to get the shot.
Vaccine mandates have been the norm, and they work. If he were alive, you could ask George Washington. That's next, as we report History as It Happens, a podcast from the Washington Times.